Hello, and welcome to the latest installment of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their owners redomesticate out of volatile legal and tax environments to more predictable pro-entrepreneurship, pro-growth jurisdictions like Texas. Today, I am reviewing a recent report by Kara Reinhardt, writing for LinkedIn News, entitled Texas Builds Y'all Street as Alternative Finance Hub, referring, of course, to the ongoing and massive migration of companies large and small to the Lone Star State. I will then conclude by explaining how business owners can use federal and state law to their advantage to relocate their existing LLC or corporation to Texas the right way, while keeping their existing federal employer identification number, contracts, bank accounts, credit history, and track record intact. But first, a brief introduction. My name is Professor Chad Daniel Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 13 professional licenses and certifications spanning accounting, tax, audit, financial planning, and of course, the law. My firm website is www.cummings.law. Now, they call it Y'all Street. The name started as a joke, but it is a joke no longer. Dallas, Texas has become the second largest financial center in the United States by employment. The Dallas, Fort Worth, and Arlington metropolitan area employed more than 386,000 people in financial services as of the middle of last year, and that number has climbed since then. Only New York City employs more, although we think that's going to change. In a concentration of financial services work, Dallas now ranks as second in the nation. The names arriving are the ones you might have expected to stay put. Goldman Sachs is spending $500 million on an 800,000 square foot campus in Dallas, expected to open in 2028 and to hold more than 5,000 employees. That will be the firm's largest United States workforce outside of Manhattan. Scotiabank has opened a hub in Victory Park, bringing more than 1,000 jobs. Fifth Third Bank, my personal favorite, is relocating to Preston Center as part of their merger with Comerica. Vanguard is opening regional offices. NASDAQ has announced a regional headquarters in Dallas, and the NYSE has expanded its own presence in Texas as well, not to mention the nascent launch of the new Texas Stock Exchange. Its phased rollout began in July of this year, with full trading and IPOs expected in early 2027 out of the new Bank of America Tower. The established exchanges did not dismiss it. They responded by following suit. Now, none of this happened because Texas ran a clever advertising campaign. Texas has no corporate income tax and no personal income tax. It has a workforce above 15.8 million. Dallas alone produces an estimated 744 billion with a B dollars in annual output. The region added more than 127,000 new residents in a single year, many arriving from California and New York. Now, consider what this migration means. Finance is the industry with the least physical reason to move. It is not capital intensive. It requires no factories, no ports, no raw materials. Wall Street stayed on Wall Street for over a century based upon that proximity factor alone. But when the industry starts building permanent, and I would add a rather large campuses elsewhere, like the massive JP Morgan campus in Plano, Texas, The reason is not simple logistics, rather, it is arithmetic. New York and California spent decades, actually centuries, assuming that concentration was permanent and priced their laws accordingly. The firms did the math and moved. Now, there is a smaller version of that same calculation available to every business owner watching this presentation. Goldman Sachs needed $500 million and 4 years of construction to change where it does business. A company with 6 employees, or even just one employee, does not. The tax difference between a high rate state like California, like New York, as contrasted with a state like Texas or even Florida, applies at every scale. And for a pass through entity, and by the way, most small and medium sized businesses in the United States, more than 90%, in fact, according to the IRS, are pass through entities. Just a quick digression there. It applies directly to the owner's personal return. These are real tax savings. Tax Foundation data that we've reviewed on earlier installments of Legal Bites indicate the average business relocating to a state without income tax retains more than $12,500 per year, and that can easily reach 6 or 7 figures in some cases. The institutions with the most invested in staying put are evacuating New York. They are evacuating Silicon Valley. If somebody is telling you otherwise, they are taking the ostrich approach and their head is firmly planted in the sand. The question worth asking now is what is actually keeping your company where it is? Now, with this context in mind, redomestication is the lesser known legal process of transferring a company's state of domicile, which is not the same thing as your personal residency, I might add, to a new state without dissolving it, without creating a new entity, and without triggering federal income tax repercussions, but only when performed with the strict formalities required by the Federal Internal Revenue Code, applicable Treasury regulations, and the statutory frameworks of both the destination and departing states. If you think this is as easy as just filling out a couple of forms and sending something through the mail, well, I won't insult you by saying you're deluded, but I will say you've got a lot to learn about this process. Now, when performed by a competent professional, that's an important proviso, the company will retain its existing federal employer identification number, contracts, credit history, and bank accounts. That is to say, there is zero operational or financial disruption, but only if you get it right the first time. That is why it is so important to work with a credentialed professional and save the DIY for home improvement. I have successfully completed redomestications from all 50 states, and yes, that includes California and New York, and for limited liability companies, partnerships, subchapter S entities, and subchapter C corporations. So if someone is telling you it cannot be done, translate that as they do not know how to do it. Now, foreign entity registration, this comes up all the time. Foreign entity registration is not the same thing as redomestication because foreign entity registration, also referred to as foreign qualification among a miasma of other somewhat misleading terms, does not change the company's state of domicile. In fact, it does the opposite. It keeps the entity in the former state indefinitely and merely adds another layer of compliance and tax obligations in the destination jurisdiction, thereby leaving you anchored to the state you were trying to leave. If all you did was file a foreign qualification statement, you did not move your company at all. Meanwhile, a traditional merger, which is still not the same thing as redomestication, creates a new distinct entity in the destination state, may and often does require the issuance of a new federal employer identification number and can trigger serious tax headaches. Finally, dissolution should not enter the conversation at all because dissolution terminates the company. It is the legal equivalent of administering lethal injection to your business. Dissolution is a going out of business maneuver, not a relocation mechanism. Dissolution is often a taxable event, and when performed inadvisedly, can expose the owners of the company to unlimited personal, yes, you heard me right, personal, joint, and several liability for the company's liabilities, known and unknown. That should be enough to keep you awake at night. This is because the so-called veil of protection no longer exists because the company no longer exists because it has been dissolved. Simple logic. If you think dissolution is a cost-saving maneuver, you are in for a rude awakening. And if you have a so-called professional suggesting dissolution as a relocation stratagem, I encourage you to seek better advice before you make a mistake you cannot undo. This is important, listen up. Redomestication, when paired with a change of personal residency and that's an important and, it's not an or, it's an and, a reduction or outright cessation of business operations in the former state can reduce or even eliminate state tax exposure for the entity and its owners in that former state. Do not take my word for it. Go read the case law. This is what the Supreme Court of the United States has said for the better part of a century. Now is the time to consider acting, as the various state legislatures are actively considering changes to their respective state law to hinder or even eliminate the option of redomestication. If you have questions regarding potentially redomesticating your existing LLC or corporation to Texas, please use the link in the description or in the bio for more information on this legal process and to schedule time for you and I to speak one-on-one about your specific situation if you so desire. Again, my name is Chad Daniel Cummings of the firm Cummings & Cummings Law, and I hope that you found this information informative. As always, the information in this presentation is necessarily general in nature and is not legal or tax advice, nor should it be construed as such, because that advice definitionally must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my many earlier presentations on this topic, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to that opportunity to speak and perhaps even work with you very soon.